of you. On the behalf of ISF College of Pharmacy, am I audible, Tripti ma'am?
Yes, please.
Thank you, sir. A very good morning to all of you. Respected Chairman, sir, Shri Parveen Garg ji, ISFCP Moga, Secretary ISFCP and Chairman TLF School, Mr. Engineer Janesh Garg ji, Dr. Muskan Garg, Director ISFAL, Director cum Principal Professor Dr. G.D. Gupta sir, Vice Principal Dr. R.K. Naran, all HODs, dear faculty members and my dear students. We welcome you all in this national seminar on Intellectual Property Awareness Program under National IP Awareness Mission in collaboration with ISF College of Pharmacy Moga, Punjab and PSCST Punjab under the aegis of IQAC and IPR. I welcome our speaker, Tripti Pandey ma'am. Tripti Pandey is working as an examiner of patents and design in Patent Office, Delhi. She completed his BSc in chemistry from Ramjas College, University of Delhi and MSc in organic chemistry from University of Delhi. Presently, she is working as an international affair division in the Indian Patent Office, Delhi. We welcome you, Tripti ma'am, on the behalf of ISF College of Pharmacy in this national seminar. So you may proceed. Tripti ma'am. Ma'am, can you hear me? Tripti Pandey ma'am.
Hello. Can you hear me now?
Yes, ma'am. Yes, you are.
Sorry,
you are audible. Okay.
I think I was on mute. Okay. So let me. Okay. Can you see my screen also?
Yes, ma'am.
Okay. Let me begin. So good morning, everyone. We are here for IPR awareness program. So most of you would be wondering why this awareness program, why IP, and what is its importance. So let me introduce this topic to you, and I hope after the end of the session, you all will, come to know why we are here for. So this awareness program has been conducted to tell you why this IP is important and how you people, the creative minds of India, can protect their invention, their creativity. So let me start with data in front of you. This is the data of ranking based on the filing activity in 2020. So as you can see this data, China leads in terms of patent, trademark, and design filing.
The slides are not moving.
Okay. Is it? It is that China is leading in terms of patent, trademark, and design filing. And look at the rank of India. It is in 9th, 6th, and 13th rank respectively. That means since we have the second largest population and we have the creative minds like you, then what is the reason that India is not at par with other countries? So there is that is why we are here for. We are here to impart that level of awareness among the students and the faculty members that you need to and you should protect your creativity, and so that economic growth of the country is also possible, and also the growth of you as an individual and as an institution is also possible. So this intellectual property, this term comprises of two terms, intellectual and property. Property, if I say, whenever we hear about property is something that fetches us money, that makes our future secure, that give us a sense of belongingness, that yes, it is something which belongs to me. So if I give you certain examples of property, you can say land, or your house, or the vehicle you own, the shops, the jewelry. So there are three types of properties. So immovable properties, movable properties, and the third, and one of the important, is the intellectual property. So if I say what are immovable properties can be your house or your shop or your lands, and the movable ones are your vehicles or the jewelries that you can move. But what about the property created by your mind? Because our mind is a creator, and that property is called intellectual property. So if I define IP means a creative ideas or expression of the human mind that have certain commercial value. So let us suppose that we have an idea that I want to produce something, I want to invent something, I want to, do something creative, but it is just in our imagination and we have not converted into something which is fruitful. So that doesn't contribute under IP, because IP means that have certain commercial value, you have an intellect and you have ultimately converted it into something which is like a property to you. So there are 5 types.
When slide is not moving, can you just?
I don't know why.
Okay. You can use
Okay,
the cursor.
I'll do that. Okay. So if I say the types of intellectual property, there are mainly 5 types of intellectual property: patents, designs, trademark, geographical indications, and copyright. So I think most of you have heard about it, but today I'm going to, little bit, explain it to you. So patents is something which is an exclusive right granted for the invention which are based on a product or a process. So either you have invented a product or a process, you can protect your creativity by filing for patents. If it is a design can be any shape, any pattern. So the pattern and the shapes are registered under that. Trademarks are given for any logos, any symbols. So trademark is for that. Geographical indication is for things and a product, a specific product belonging to a particular geographical area, so that GI tag is given to that particular product. And copyright is given for all the literary, artistic, dramatic, musical works. So these are the 5 broad intellectual property that I am going to discuss with you one by one. Okay, so let us start with different IPs that are present in a single product. So all of you are connected to me with certain laptops or mobile phones. So do you even realize that your mobile phones and your laptops have more than 500 patents? Because obviously somebody have invented the display, somebody has invented the touch panel, the processor, the keyboard, the mouse, and everything like that. So all the invention part is covered under the patents. And the design of your laptop or the mobile phone you are using is registered under the Design Act. The sign, the logo at the back of your mobile and the laptop is registered under the trademark, and the manual that come along with your all the electronic goods is your copyrighted material. So see, we use these things, but we don't even realize that there are so many IPs, and we if we know that these IPs exist, we may have protected it. Like in future, you may invent something, and it is not like the invention part only, but the design should also be registered, the logo that you are using should also be trademarked, the writing part should be copyrighted. So these are the different IPs that I want to explain. So let us start with patents. What our act says about invention? So we usually say that I have invented something, but there is a difference. What is an invention according to as per our act? Our act says that invention is a new product or a process. So basically it should be new. New means novelty. We basically look for novelty. It should be new. It must have an inventive step. Means it should not be obvious to the person. Like I am working on something and I know that by adding this much, this will change, and that has already been written somewhere. So it is something that I have not totally it is new, because I have combined the teachings from different documents, and I have just tried to do something. So it is not a case of non-obviousness. So invention should have certain inventive step. And the third is the capable of industrial application. That means it is something that can be produced in the industry. Like you are a pharmacy college, if you have invented certain drugs, so that can be, industrially produced. So that is what I'm explaining, that invention should be a new product. It must have an inventive step and it is capable of industrial application. See, these are the most famous patented invention, if I tell you, because whenever we hear about bulb, Thomas Alva Edison's come to our mind. Whenever we hear about telephones, Graham Bell come to our mind. So how these people are associated with these inventions? Because they have patented their work. Till today, we know that yes, whenever we talk about telephone, we are going to talk about Graham Bell. And see, it was in 1876 that he got patent for his telephone, and it was in 1880 that Thomas Edison got patent for his incandescent lamp. So that means that if you want to associate your name to certain invention, even the advanced version may come in future, but you need to patent, you need to file for patent applications. The third one is this bicycle, which is patented in the name of CD Rai. So he has got a patent over it in 1890. So these are the famous ones. Another example I would give you is of the traffic signals that we usually, and we see it, everyone knows about it. So this traffic signal, you will be surprised to know that before 1923 there was no concept of traffic signal, but Garrett A. Morgan witnessed a terrible accident, and there he decided that we need to have certain things, we need to have certain innovation that can protect the lives of others. So see, this invention has made the life safer. And this is what I want to convey, that you must look around and try to analyze things, and try to analyze it. Even a simple thing that could make your life convenient or safer can be patented. So it need not to be something out of the box, it can be something which is related to our day-to-day life also. So I am talking a lot about patents, so let me explain you what a patent is. It's an exclusive right granted by the government to the patentee, and obviously for a new product or a process. And what the right is that you can exclude others from making, using, or selling your invention without your consent. So if anybody does that, like you have got a patent over it, and if anybody tries to commercialize your product, obviously you can take necessary steps against that person. And this protection is given for 20 years. And in exchange, you have to disclose your invention to us, because obviously we want to encourage the creativity, we want to encourage the culture of innovation in the country. So you have to explain it to us so that other people could, can bring an advanced version to it. And the most important is that it is a territorial right. So the government of India provides you the protection within the territory of India, and beyond that, it is not applicable. So if somebody else is trying to infringe your invention sitting in US or in Europe, then you need to file for patent in that respective countries also, because the patent that you acquire in India is applicable within the boundaries of India only. Okay. So why should we patent our invention? First of all, I have told you that it will give you an exclusive right that you can stop others from imitating your work. But what else? Since I talked about property, so is it something that is going to, fetch you money? Is it something that, going to secure your future? Yes. So here I'm going to tell you about the benefits. So first benefit, as I have told you, that it will prevent others from imitating. Another one is that you can have commercial gains over it. And how? You can either manufacture it by your own and sell it in the public. You can open your own, industry or your own firm, and you can start selling your inventions. Or you can give license to others. You can give license to other person or other companies who can sell it on your behalf. So this is the way you can earn money. Another example, another benefit is attracting funds and investors. If your invention is patented, so obviously people know that this is something that has never been invented before, that has never been known before. So obviously it is something which is very new. So the investor might want to invest in your work, might want to, commercialize it on your behalf. So it will ultimately attract funds from the investor. It will build the reputation of you as an individual and also of your institution. and it will boost the culture of research and development in our country, because if you have invented something and we are disclosing it to the public, so obviously people will come to know, yes, this is something in which work is going on, and we can advance it, or we can use this technology to invent something new. So a culture of research and development will prosper, and ultimately we'll have economic growth, because every contribution that you do leads to the growth of the country only. So yes, these are certain benefits of patenting of invention. So can we patent everything? So let me tell you, these are the patentable subject matters. First of all, it could be a new product, so a new drug, if you have invented a new drug, or a new compound, so obviously it could be patented. But obviously it has to fulfill those three conditions, that yes, it is novel, it is inventive, and it has certain industrial application. Another thing that could be patented is a composition of insecticidal composition or a skin care composition. It could be anything, a polymer composition. So yes, it could be patented. Another one is a process. If you have prepared a compound with a new method, which has increased the efficiency of that product, which has increased the therapeutic efficacy of that product, so obviously that preparation method can also be patented. A device, if you have invented a device, it could be any medical device or chemical apparatus which is new, unique, and that can also be patented. So these are some examples of patentable subject matter. And now, who can apply for patent? So yes, let me tell you this, anybody can apply for patent. There is no age limit for applying for patent. If you have invented something, you can apply. You can be true and first inventor of that invention. You can be the assignee of that person. Like if you want to assign a company or a person or legal representative of yours, you can also assign the rights to that person, and that person can file the application on your behalf. Another thing is, if the person is deceased, like he has invented something but now he's no more, then the legal representative of that person can also file for patent. That and all the application can be made alone or jointly. Like if you have you are two friends or two or more friends, or your institution and you have invented something, so then you can also file for jointly. You can file a joint application in that case. I have also given the link where you can directly go and you can file the application for patent. This is for patent filing. Now the points to remember, like if you want to file the application, please remember the following points. First is, first file for a patent and then publish. Because what happens is, we often look for prior arts. We try to see that whether this is something which has already been published before in the known to public or published before. So obviously this will create a problem, that if you have published your work before and filed for a patent later on. So I would say either go first file for the patent and then whatever you want to do with your work. And never display or share your invention, because what happens is, whenever we invent something, we try to tell it to our friends, our colleague, our senior, or everybody, because obviously we are excited. But sometimes what happens is, they might disclose it to others. They might publish it before you file for patent, or maybe they will file for patent before you. So that is what we say, that please file for patent and then tell to others, then publish. But what if our invention is not fully developed? Like I have started working on something, but I have not reached to that point that I can file for patent. What should I do in that case? So I will tell you about a concept of provisional filing. In that case, you can just file for the work you have done so far. You can tell us that, yes, this is what I am going to do. This is what my final product is going to look like. And this is the gist of my invention. After that, you will get a 12 months time period to file a complete specification. In that 12 months time, you can decide whether you want to go ahead with your work, or you want to, withdraw your work. So you can decide on that. But if you have not filed, you'll lose that date of filing, and maybe somebody else will file before you. So that is what I'm saying, that file for your invention if you have started doing something. And this is again important, that one patent covers only one invention. So if you have different inventions in your mind, if you have invented multiple drugs or multiple compounds, then you must file for different patent application. You'll have to pay different fees, you have to fill different forms, so that you can look in our website and you'll come to know that what are the requirements for filing. Okay, so this was all about patent. Now I'm going to start with design. So design registration is another important intellectual property, because as I gave you the examples of the laptops and the mobile phones, you can also see the the shapes of your laptops. Or if you have, you observe cars and bikes with different shapes and different models having, different pattern in and they are all registered. That is why I don't see a copy of a car. Like, even the if you don't read the name of the car, you often realize that yes, this is this one, because that design, the design captative in design is in your mind, that yes, this is the one, because that design is never imitated if they have registered it. So the registration becomes important. Not only the designs on the car or the shapes of the car and the bike, but the designs on the jewelries, the design by the designer, fashion designers, they are all registered if you don't want it to be copied, obviously. So designs are judged by the eyes. You have to, apply it to some article, and then you can file for its registration. And design can be any shape, any configuration, or any pattern, and it must be applied to certain article. Like if you have seen a crockery set, if you see a pattern or a design in the sets, they are all registered because they have applied that to an article. Okay, and a jewelry design and other things. So these are certain examples. If you can see, these are the examples and another examples. So can all the design be registered? So the registration of designs come with certain restrictions, that it should be new. First of all, this is very important in all the IPs, that it must be new, it must be original, it must not be copied from somebody else. Another one is it has never been disclosed in the public, because again, we see for prior arts, we see that whether at the date of filing this application was ever been published, was ever known to public before. So if somebody else have, and also for prior art, we look, worldwide. It is not like within the boundary of India. So for prior arts, we look for any places, whether it has been published or not. And your design should be distinguishable, like it should be different from already known designs, and it should not contain any scandalous or obscene matter. So these are the conditions for design registration. So if you have any design on your mind, so obviously you can go for the registration part. Now let me start with trademark. Okay. So many of you maybe in future will start their own startups, maybe will start their own something, they'll start their own work, their own business. So if you want that recognition, if you want to build that goodwill, so you will obviously put a name or a word or a symbol for your company, for your brand name, because obviously you want to be recognized by that brand name. So here the trademark concepts come into picture. So what happens is, whenever we want to buy something, we look for the brand name, because we know that these brands are associated with such products and they have built that reputation. We know that yes, this brand has this quality. So this what trademarks does, that they give you a brand value, they give you a goodwill and a reputation, and it depends upon the company that whether they survive or not in the market, but yes, it distinguishes your products from other products. Okay, so if I give you examples, these are examples. So whenever we hear, I want to eat pizza, for examples, so I know that I will go to Pizza Hut or Domino's because they serve a good quality pizza. For a burger, I would go to these two places. And see, in most of them, I have not even written the names. These are just the logos. But we know that yes, this is of Puma, or this is of Nike, or this is McDonald's, or this is your Pizza Hut, this is Domino's, this is your Pepsi. So see, these are the things, and these are the products, and these are the logos. They are all associated. They have built that goodwill, they have built that reputation, and you need not to, so this trademark is something which gives you that. So that is what I'm saying. Trademark registration becomes important if you want to be distinguished from other products. So what is a good trademark? A good trademark is something which is distinct, which is different, and it is not similar to the existing mark which is already in the market. It has been honestly adopted, it has not been copied, or you have not tried to steal it from others. And what I would say is that before registering for the trademark, you can check for the already available or already registered trademark. In that way, you will come to know that whether such trademark already exists in the market, and that will also help you in avoiding the unnecessary litigations and paying unnecessary fees to us. So yes, these are certain examples, and these are some more examples. So not only the brand but also the service providing company like Naukri.com. Okay, so these are other some few examples. So you can see that they can also have the trademark. To recognize whether they have obtained a trademark, you can see the symbol R. The symbol R signifies a registered trademark. So whenever you see this logo and with a R marked, so this is something which has been registered by the office. But what about those marks that have TM written over them? Okay, so there are certain logos that have TM written. That TM is something that they have filed for registration. They have not got a registered trademark. They have filed for it, or they just want to convey that yes, we are the first owner of this product. But until and unless we have registered your trademark, you will not get any benefits. So do you really need to register your trademark? No, it's an optional thing. If you don't want, don't do it. But it has certain advantages, as I told you, that for example, you have started selling a product in the market with the brand name, but you have not registered it. Maybe somebody else will open the same a shop selling the same product with the same brand name, and maybe will attract your customers. You cannot then prove it that yes, this was your product at the first place, or this was your trademark at the first place, because you have not registered it. So to get that authenticity that yes, this was my product, I was the first owner of this trademark, you should register it. And this trademark can be renewed for indefinite period. So initially it is granted for 10 years, and after that you can renew it. Okay, now we come to another IP, intellectual property, that is your copyright. So I have told you about inventions, I have told you about designs, I have told you about the logos. Another one is your copyright, that is given for your literary work, for your dramatic work, for the musical notes, for the artistic work. Like many of you love to draw, love to sketch, love to write, or be to perform something. So all these things, all the artistic work that you do, maybe in future you will write a book. So all the literary work is something that is a copyrighted material. So they are protected under the copyright. So you know what, this is the right which has a automatic thing, because automatic right is something which is granted as soon as you do it. As soon as you write a book, you have got a copyright over it. As soon as you have painted a painting, you have got a copyright over it. But since you have not registered it, it is just that yes, you have got a copyright over it, but in case of infringement, or in case you don't want it to publicize it, you don't want to sell its copy, you need to register it. So see, you have got an automatic right over your work. So all the authors, painters, sculptors, architects, musicians, as soon as they do something that is artistic, they got this right. But if you want to limit the people who can use your product, or you want to prevent the unauthorized copying of your product, or you want to decide whether who can see it and who cannot, you need to register it. So here again, copyright registration is optional, but if you do it, it will help you in case somebody else is trying to infringe it. So these are the subject matters that are copyrighted. So all the literary work, artistic work, musical work, dramatic work, sound recording work, and the cinematographic films. I have not repeated the benefits of filing for these, because I think all the benefits are same. If you register your design, you'll get the same benefits as you get in the benefits in case of patenting. Similarly, in case of trademark and the copyright, like if you are protecting your work, you will be have this exclusive right. You can decide what you want to do with your work. So again, I will emphasize on this that yes, it's a property that is fetching you money. You can decide who can see it, you can give license to other, and you can take necessary actions against that infringer. Okay, now we come to one of this is again the important one, because other protection, other IPs were something that is created by an applicant, but here this IP is something which is given to already existing, assets of our country. This is geographical indication, as the logo says, the Atulya Bharat ki Amulya Nidhi, invaluable treasures of incredible India. So we have, a lot of treasures already existing in our country, and this IP protects those treasures. So let me start with the name geographical indication. As you can see, geographical indication comprises of two terms. So basically, geographic indication is related to some geographical area and have some special qualities, special, parameters attributed to it. So if I give you an example, like first GI tag was given to Darjeeling tea. So this Darjeeling tea has a unique aroma, has unique leaf size, has unique, taste, and it is grown in a specific climatic, specific temperature, specific rainfall is required, specific soil is required. So obviously it is a unique product belonging to a unique geographical, conditions. So that is why this tag is given. So if I give you certain examples, so Darjeeling tea I have already told you. Another one is your Makrana marble, the Sangmarmar we say. So the Taj Mahal is made up of this marble, which is, which was exported from Rajasthan. So yes, Ratlami save is again have a unique taste to it. The Kanchipuram silk. So these are all the name of the places, and look at the things that are, a part of it. So the Chanderi fabric of Madhya Pradesh, the Lucknow Zardozi work, the Madhubani paintings of Bihar, and Alfonso mangoes from Ratnagiri, Maharashtra. So as you can see, these are all your products belonging to a specific geographical area. This I have already told you, but I would like to mention it here also, that patents are given for 20 years term only. Designs are for 10 years terms, and it could be extended to another 5 years. Trademark is initially given for 10 years and then it could be extended to indefinite period. GI is again for 10 years and then for indefinite period. Copyright, in case it's a literary work, the dramatic or the artistic work, it is given till the lifetime of the author and for another 60 years after the death of the author. So these are some of the validity that I have mentioned. Okay, so now I had a quiz, but I think I'll just take your questions instead. So let me also discuss about the careers in intellectual property, because since we all are the students and we usually have this in our mind that if we are not able to invent something or we don't have that creativity to, file for something that is very unique or out of the box, can we in other way contribute to this intellectual property? So I would say yes, you have other career options also, you can go for that. You can become an examiner or a registrar in government offices. Obviously these has different eligibility criteria that you have to check. You can become a patent agent or an advisor, IP advisor to a person. In case of infringement, as I have told you, you can become an IP lawyer, because obviously there are so many people whose work are infringed. So who is going to fight for them? A lawyer. A patent drafting specialist, because an ordinary person don't know how to begin, how to file for patent. So obviously that drafting specialist could help in. And also you can become an analyst. So these are some of the career options. You may check them if you want. And also, since this was just an awareness session, so I was here to just, make you familiarize what IP is, why it is important, and why this awareness program was conducted. That was my main aim. But if you want to go for further trainings, or you want to know more about any IP, any patent, or you want to file for it, you can also contact our, Arjun IPM. It's a training institute of Government of India, where they'll give you certain virtual sessions and also the offline trainings, and will guide you more about it. Okay. So this is our website, www.ipindia.nic.in. So if you want to file for anything, patent design, trademark, GI, or copyright, you can visit this website and you can file for, because there are two options. You can either do e-filing or you can also visit to our office and file offline. So thank you so much. I hope I was able to do my part, and now the forum is open for questions. You can just type in the chat box, or you can also ask me the questions. Okay?
Thank you. Thank you, Tripti ma'am, for this wonderful session and excellent information regarding design, patents, copyrights, and other things, scientific things. Now I request to my co-coordinator, Dr. Vineet Rai, HOD, Department of Pharmaceutics, to further proceedings. Dr. Vineet Rai.
Thank you so much, ma'am, for this wonderful session. And I think you have delivered a lot about the IPR and policies and why it is required in securing our ideas. So we have some questions, ma'am. And one of the questions from Naresh Rangaji, and he's asking that can I patent any idea? Anything can we patent?
So as I told you, you can patent any idea if it has certain commercial value. It should be, converted into certain things that can, have certain commercial value. It should not be idea in your head. It should be idea in front of us. So yes, if you have certain thoughts, please convert it into something productable, and then we'll analyze it on the basis of our criteria. And yes, you can patent it.
Okay, thank you, ma'am. So another question from Divya Jyoti Roy, and is asking, ma'am, how can we check that there are any existing patent of my idea that I am patenting for?
Okay, so you can do two things. First of all, you can either search in Google Patents. I would say it's a very good and informative place where you can find all the patents. Just write the keywords of what you are thinking, and you'll get several patents and several works which has been done on it. Another thing is you can visit our IP India website, where there also you can have keyword search, and you can search for your invention if anything has been done on your work or not. So you can do that.
Okay. I think you have conveyed the message, ma'am. Thank you. And now one question from Jyoti Sharma. She is asking, what is the difference between patent protection and trade secret protection?
So patent protection is given for your work, like you have invented something and we'll provide you with that patent protection. Trade secret is something, first of all, in India, we don't have any trade secret law. Trade secret law is defined by other law, like the contract law and other laws. So we don't have a particular trade secret law, but yes, if some parties have decided that they don't want to disclose it in the public, so these laws are governed by, with the parties that are part of it, and not the government of India. Government of India, you have to file for patent and we protect your patent. Trade secret doesn't have a law as such in our country.
Okay. Thank you so much. I think Jyoti has got the message. And one of the questions from our respected faculty member, Balagdas ji, how to convert IPR in financial benefits?
So while I was discussing the benefits of patenting, I told you that yes, you can, first of all, you can sell your product by your own. You can give license to others. You can decide upon the royalty that you want. See, if you have invented something and some company wants to commercialize on your behalf, you can ask for royalty. You can ask them that yes, for each individual product, you have to pay me this. So you can do that, or you can just entirely sell your work. You can just give it to others. They can, commercialize on your behalf. So these are the way of commercializing it.
Okay. Sure, sure. Thank you, ma'am. One more question from Amisha, and she's asking that who can apply for geographical indication and what are its criteria for selection? Actually, ma'am,
Okay.
geographical, we are working in the field of pharmaceutical sciences, and I think geographical indications are rarely filed or registered under this category because it is related to some specific area. So,
Yes.
can we file any geographical indication as a pharmaceutical scientist or pharmaceutical
See,
the scholars related to the pharmaceutical field.
right.
Yeah.
Geographical indications are not filed by individual. Let me tell you this. It is filed by the organization representing the growers or representing the people who are working for it. Like if for the Darjeeling tea, there is an organization, a tea board that has filed for its application. So the organization that represent the that growers or that manufacturers, they filed for the first of all GI, and the criteria for selection, as you said, criteria for selection is as I told you, it must be unique to that geographical area. It should have a uniqueness not only to the geographical area but to the product quality also. That should not be known. If you know that the Bengal Rasagulla and the Odisha Rasagulla both have got their GI tag, because both are Rasagulla, but they have their unique taste, unique making style. So that is what I would say, that yes, it's a community right, and not somebody can come up and file for GI. So yes, it is filed by the organization.
Okay. Thank you, ma'am. Thanks for your answer. And we got one very interesting question, that any official platform for patent agent community? And
Okay.
Prateek Chauhan sir has asked this question. So
Okay,
can
so
you,
patent agent exam is conducted by Government of India only. So we have a patent agent exam also. We conduct this exam. They have certain eligibility criteria and everything. So this patent agent, after they got a registration, we provide them with that number. So either you can search for that. If you have that number, you can search in our registry, or you can visit our website also. There also we'll provide you with the list of the registered patent agents. So you can have, you can see it from there.
I think Prateek sir has got the answer. And Aarti madam has asked one more question. What is the purpose of patent system? Is it the patent holder or the community benefit?
Ma'am, I would say it is a benefit of whole as whole, like everybody. Because as I told you, the examples of a telephone or the bulb or the bicycle or the traffic signal, you can clearly see that yes, it is something which is, yes, the owner has the right over it. But see, as a community, we are also availing the benefits of it. So any technology that is invented is beneficial not only for the inventor but also for the public.
Okay.
Thank you.
Thank you, ma'am. Thank you so much for answering all these questions very directly, and we are very thankful to you, ma'am.
Thank you so much.
Thank you so much, Tripti ma'am, that you explain all the answers in a very scientific way. Now I would like to invite our worthy, respected director, cum principal of ISF College of Pharmacy, Professor Dr. G.D. Gupta sir, to please conclude the session. Please, sir.
So thank you very much, Dr. Sidharth Mehan ji and Dr. Vineet Rai ji. So first of all, I am thankful to Madam Tripti Pandey ji, and the presentation was very effective, very sweet, and I can say that the presentation is like a very simply you can give a excellent manner, and so number of the things you have already clarified. Only my submission over here before to give the thanks or give more information related to this one. In those days, most of the peoples, they are interested to file the patents, but sometime number of the have the no any perfect information. So the practice in those days to only the file the patent. This is the first practice, and then they forget what happened the next step and what is the requirement. Nowadays, some of the awareness is the gradually increasing. So people is the moving toward up to the grant like that, or approval of the patent, so that awareness going on. Second part is this one is this is the copyright. So I think everybody feel that and know anybody is recognize the copyright. So if you have some of the platform, or you have to also write down either NAC, NRIF, AICT, Pharmacy Council, and other council you can write down. They have give some of the weightage of the copyright, so that person they can be involved. Otherwise, this is a simple only you can submit some of the paper and you can submit the fees, and that's over. Second is the design registration patent. There is the no value considered in the design registration patent. While I know that this is the one of the most important thing, even one of the car or any articles, it have number of the design patent, it may be the complete or it may be the segment or part like that. But no any professional body recognize the patent design like that or patent registration. So there is the two terminology, design somewhere as the patent and it is not as a design registration. So NRIF in those days, one of the most important part of any institution, university and recognition as the national level. So only the person is the moving toward the patent and patent like that. So next thing is the over here, if any person have some of the design patent and want to the commercialize, and if any people is the same to be the copied, then any some of the rules and regulation of the punishment, or it is required to be only just like I just earned the money after the copying of the product, and then somebody is the claim, then it can be the just negotiate and you can say finish like that. Because what I feel that during the SARC India tank, they have always asked the question, this product, if anybody, they can be copied it, then what is in your hand? What you have in your hand? So this is the one of the big question, and everybody want to know about this one, because being a researcher, administrator, or we can say academician, we are using mainly these three things: patent and design. Another one is the copyright. Another big part is the trademark. If we can move towards some of the commercial activity or some of the product like that. So Tripti ji, you can slightly focus on it, because if you have some of the guidelines, government of India, if this types of, then what is the rules and regulation?
Absolutely, sir. We have rules and regulations for all the questions, all the queries that you had. Obviously, it is all defined in our acts and rules. And it is good to know that you are so much interested in knowing about every aspects of it. Since it was an awareness session, so I was not able to, include all the aspects, procedural aspects. So I hope that in future we'll have some more sessions where we could discuss all the procedural aspects also, and especially focusing on patent, copyright and design, as you said. So in that we can discuss all the forms, fees, and the what you can get if in case of infringement of your work. So yes, we can discuss it in some future events for sure.
So thank you very much, because we need some of the value, because everybody want when we submit any paper and publish it. So the main factor, this is the recognized by the UGC, first factor, peer reviewed, second factor, third is the Scopus, web science, or like a impact factor. So if this thing it can be happened, then most of the scientists they can involve. And thankful to the agency and government of India for reduce the fees of the patent. Otherwise itself it is one of the fear factor and very huge fees for this one. So thank you very much, and I hope that everybody enjoyed the session. And throughout the presentation, near about the more than 60 people they are the attached over here, and number of the thousands of the people they are also available on the our YouTube channels, and this discussion is also available on the YouTube channel. So I hope that in the coming future, and if you the time will give the permitted to the institute, I hope that you can give some of the collaboration. Tripti ji, is it possible we can collaborate something to you, because this institute have the 29th rank in the India. We are the autonomous, and I want to establish one of the excellent IPR cells. So here the two person, Dr. Sidharth Mehan and Dr. Vineet ji, both are doing the work on the IPR. What this is the only for why one of the board and name over there. I want to collaborate with the some of the agency, so we can also do the lot of work and also give some of the benefit to the society also. So if some of the collaboration monthly or quarterly or bi-monthly or fortnight, if we can organize one of the activity at the national level with the collaboration of the ISF College of Pharmacy, for this purpose, if you need any types of the documentation, letter, or from anything from my side, I am ready to present over there, so that it will be the actual helpful for the education system. So if you have this type, you can give the information by the mail to Dr. Mehan or to me anyway. So thank you very much, and thankful to the management committee to provide always opportunity to conduct this types of the session. and thankful to both of the organizer, Dr. Sidharth Mehan and Dr. Vineet Ji, for organizing this activity, and very special thanks to today's expert and very dedicated Tripti Pandey Ji. And I just want to say that most probably the pitch of the ladies is the quite comfortable. What your voice is the like that, each and every word like that, we all are present physically over there. So excellent presentation throughout the presentation. You have the smile, because face value also give the most thing to the people. So from my side, good luck to you. You can grow and grow throughout your life. As and when you have need any types of the assistance from this institute, from my side, and as a professional, I will be the happy to work together with you. So thanks to all, and thank you very much.
Thank you so much, sir.
Thank you, Director Sir, for your wonderful motivation and enlighten the session. Now I want to conclude. I want to thank my gratitude regarding Office of the Controller, Journal of Patent, Design and Trademarks. I also want to thankful Mr. Shiv Prakash Ji, who is from Indian Patent Office, who give us opportunity and collaborate to strengthen this session in a very scientific manner. I also thankful to all participants who successfully joined and complete this session. Thank you so much to all. Thanks.
Thank you so much.
Okay.
Thank you, ma'am.
Thank you, ma'am. Thank you all.
I request all participants